Right now, there's a lot of fear and confusion spreading online about a massive immigration reform that supposedly just passed. You might have seen videos claiming that millions of immigrants have suddenly lost their protection, that green card holders are being deported for minor offenses, and that everything changed overnight. But here's what you need to know. Those claims are not accurate. The truth is both more complicated and less terrifying than what's circulating on social media. Today, I'm going to give you the facts about what's actually happening with immigration law, what H.R. 875 really is, and most importantly, what you need to do to protect yourself and your family. This is U.S. Visa Updates, and by the end of this video, you'll have the clear, honest information you deserve. Welcome to U.S. Visa Updates, where we cut through the confusion and give you accurate, reliable immigration information that can help you make informed decisions about your future in the United States. I'm committed to being honest with you, even when that means correcting misinformation that's spreading online, because your future and your family's future are too important for fear-based content or misleading claims. Today we're talking about H.R. 875, officially called the Jeremy and Angel C. and Sergeant Brandon Mendoza Protect Our Communities from DUIs Act. This legislation has been the subject of many videos claiming that massive immigration changes have already taken effect, but that's not accurate. So what's the real story? Let's break it down step by step, starting with what this bill actually is, what stage it's currently at in the legislative process, what it would do if it becomes law, and what the current rules actually say about DUI offenses and immigration. Part 1, what H.R. 875 actually is. First, let's be absolutely clear about the most important fact. H.R. 875 is currently a proposed bill. It is not law. It has not been enacted. Nothing has changed yet in terms of immigration enforcement. Here's the actual timeline. H.R. 875 was introduced in the House of Representatives by Representative Barry Moore from Alabama in early 2025. The bill passed the House of Representatives on June 26, 2025, with a vote of 246 to 160. That means the House approved it. But that's only one step in a much longer process. After passing the House, the bill moved to the Senate, where it was referred to the Senate Judiciary Committee. As of today, December 2025, the bill is still sitting in that committee. It has not been voted on by the full Senate. It has not been signed by the President. It is not law. For any bill to become law in the United States, it must pass both the House of Representatives and the Senate in identical form and then be signed by the President. H.R. 875 has only completed the first step of this three-step process. The Senate could pass it, modify it, reject it, or simply let it sit in committee indefinitely. Even if the Senate passes it, the President still needs to sign it. Until all of these steps happen, this bill has no legal force. So when you see videos saying Congress has officially passed this law or that millions of immigrants have suddenly found their lives turned upside down, those statements are false. The reality is that one chamber of Congress passed a bill, and now we're waiting to see what happens next. Part 2, what H.R. 875 would do if enacted. Now let's talk about what this bill would actually do if it does become law, because understanding the proposal is important for preparation and planning. H.R. 875 would make significant changes to how driving under the influence offenses affect immigration status. Specifically, it would add two new provisions to the Immigration and Nationality Act. The first change involves inadmissibility. The bill would create a new ground of inadmissibility for anyone who has been convicted of a DUI or DWI or who admits to committing the essential elements of a DUI or DWI offense. This would apply regardless of whether the offense is classified as a misdemeanor or felony under state, local, tribal, or federal law. In practical terms, this means that if the bill becomes law, a single DUI conviction could make someone inadmissible to the United States. This would affect people applying for visas, green cards, or adjustment of status. It would also affect green card holders who travel outside the United States and then try to return because they would go through an inadmissibility determination at the port of entry. The second change involves deportability. The bill would create a new ground of deportability for anyone convicted of a DUI or DWI offense. Again, this would apply regardless of how the jurisdiction classifies the offense. This means that a conviction, even for a first-time misdemeanor DUI, could subject someone to removal proceedings. One of the most concerning aspects of the bill is that it does not include any temporal limitation. This means it could potentially apply to convictions from years or even decades ago. The bill also does not provide for any discretionary waivers or exceptions. Under current law, immigration judges and USCIS officers sometimes have discretion to consider factors like rehabilitation, family ties, and length of residence in the United States. This bill would remove that discretion for DUI cases. It's also important to note that the bill would make even an admission to DUI conduct a basis for inadmissibility, even without a conviction. This is particularly significant because admissions can happen in various contexts, such as during visa interviews, adjustment of status interviews, or even during traffic stops if information is later shared with immigration authorities. The White House has expressed support for this bill, and it does have bipartisan backing, though the vote in the House was largely along party lines. Immigration attorneys and advocacy groups have raised serious concerns about the bill's breadth, its potential to separate families, its lack of proportionality, and its elimination of discretion for immigration adjudicators. Part 3: Current Law on DUIs and Immigration. To understand why this bill matters, it's important to know what the current rules actually are. Right now, under existing law, a simple DUI is generally not an automatic ground for deportation or inadmissibility. That doesn't mean DUIs never have immigration consequences. They absolutely can, but it depends on the specific circumstances. Under current law, a DUI might create immigration problems if there are aggravating factors. These can include multiple DUI convictions, a DUI that involved a controlled substance rather than just alcohol, a DUI that resulted in injury to others, driving without a license, having a child in the car, or other factors that might make the offense more serious. In those cases, immigration authorities might argue that the DUI constitutes a crime involving moral turpitude or falls into another deportable category. For people applying for naturalization and citizenship, a DUI on your record can affect the good moral character requirement. Multiple DUIs, especially if they occurred during the statutory period for demonstrating good moral character, can be particularly problematic. However, under current law, people with DUI convictions do sometimes successfully naturalize, especially if they can demonstrate rehabilitation, if the offense was isolated, and if they have otherwise maintained good moral character through employment, family ties, community involvement, and tax compliance. For undocumented immigrants, a DUI arrest can be particularly dangerous, not because the DUI itself is necessarily a deportable offense, but because the arrest brings you into contact with law enforcement, which can then lead to ICE notification and detention. Once you're detained by ICE, your lack of legal status becomes the basis for removal proceedings, not the DUI itself. Green card holders need to be especially careful about international travel if they have any criminal history, including DUIs. When you return to the United States, you go through the inadmissibility screening process. Depending on the facts of your case, criminal history, including certain DUIs, could potentially trigger questions and problems at the border. Though again, under current law, a simple DUI without aggravating factors is not typically sufficient by itself to deny a green card holder re-entry. Part 4: Why this bill has generated so much attention. You might be wondering why this particular bill has generated so much discussion and concern in the immigration community. There are several reasons. First, the bill is extremely broad. Unlike current law, which requires aggravating factors or multiple offenses, H.R. 875 would make a single DUI, even a first-time misdemeanor, a categorical ground for inadmissibility and deportability. Immigration attorneys point out that this treats a DUI as equivalent to much more serious crimes in terms of immigration consequences. Second, the bill eliminates discretion. Under current immigration law, officers and judges often have the ability to consider the totality of circumstances. They can look at factors like rehabilitation, the passage of time, family ties, contributions to the community, and whether removing someone would cause exceptional hardship to U.S. citizen family members. H.R. 875 would remove that discretion for DUI cases, making the consequences automatic. Third, the bill appears to apply retroactively. The bill doesn't include language limiting it to future convictions only. This means that someone who had a DUI 10 or 20 years ago, who has since maintained a clean record, raised a family, built a business, and contributed to their community, could still face deportation or inadmissibility under this law if it passes. Fourth, the bill includes admissions, not just convictions. This is unusual and concerning. You could be deemed inadmissible simply for admitting to the essential elements of a DUI, even if you were never charged or convicted. This could come up during visa interviews, adjustment of status applications, or other interactions with immigration authorities. Finally, there's concern about proportionality. Immigration advocates argue that while drunk driving is absolutely a serious issue that endangers public safety, the immigration consequences created by this bill are disproportionate, especially for first-time offenders or cases without injury or property damage. They point out that this bill would result in automatic deportation for conduct that might result in probation, a fine, and classes for a U.S. citizen. Part 5. What should you do right now? Given all of this information, you're probably wondering what you should actually do. Here's my practical advice based on the current situation. First, understand that nothing has changed yet. If you have a DUI on your record, you are not suddenly deportable today because of H.R. 875. The current rules still apply. Don't make any panicked decisions based on videos claiming that everything has already changed, because that's not true. Second, if you have any criminal history, including DUIs, and you're a non-citizen, this is an excellent time to consult with an experienced immigration attorney. Whether or not H.R. 875 becomes law, it's wise to understand how your specific situation might be affected. An attorney can review your case, tell you what your risks are under current law, help you understand what might happen if this bill passes, and advise you on steps you can take now. Third, if you're eligible for naturalization and citizenship, this is a strong reminder of why citizenship matters. U.S. citizens cannot be deported. If you have a green card and you're eligible to naturalize, seriously consider moving forward with your citizenship application. Citizenship is the ultimate protection. And once you're a citizen, bills like H.R. 875 won't affect you. Fourth, if you're a non-citizen and you're considering traveling outside the United States, especially if you have any criminal history, consult with an immigration attorney before you travel. International travel can sometimes trigger inadmissibility issues at the border, and it's better to know what your risks are before you leave rather than finding out when you try to return. Fifth, if you're facing DUI charges right now, it's absolutely critical that you work with both a criminal defense attorney and an immigration attorney. Your criminal defense attorney needs to know about your immigration status so they can structure any plea deal or resolution in a way that minimizes immigration consequences. Not all criminal outcomes that look similar actually have the same immigration impact, and an experienced attorney can make a huge difference. Sixth, avoid driving under the influence. This should go without saying, but it's worth emphasizing. Drunk driving endangers lives, and it's never worth the risk. Beyond the obvious safety and legal issues for non-citizens, even under current law, a DUI can create significant immigration problems. If H.R. 875 becomes law, those problems become much more severe. The absolute best protection is to never drink and drive. Part 6, How to Monitor This Bill. If you want to follow what happens with H.R. 875, There are reliable ways to do that. You can visit congress.gov and search for H.R. 875. That official government website will show you the current status of the bill, any actions taken, and the text of the legislation. You can also check with immigration law organizations like the American Immigration Lawyers Association, which provides updates on significant pending legislation. Many immigration law firms also publish updates on their blogs and websites about significant pending legislation. Following several reputable immigration law firms can help you stay informed about developments as they happen. If this bill does move forward in the Senate, there will likely be hearings, public comment periods, and debate. These things don't happen overnight, and they're not secret. You'll have time to prepare and respond if the bill advances. Part 7. The Bigger Picture. It's worth stepping back and looking at the bigger picture here. Immigration law is complex and it's constantly evolving. Bills are introduced in Congress all the time. Some pass, many don't. Even bills that have strong support can stall in committee, get significantly modified, or fail to get enough votes. The fact that H.R. 875 passed the House is significant and it's worth paying attention to. The White House support increases the likelihood that it could become law, but we're still in the middle of the legislative process and many things could happen between now and final passage. What this situation really demonstrates is the importance of staying informed through reliable sources. It's easy for misinformation to spread on social media, especially about immigration, because these topics generate strong emotions and people are understandably anxious about their futures. But panic based on false information doesn't help anyone. What helps is accurate information, good legal advice, and thoughtful planning. This is also a reminder that your immigration status matters. If you're in the United States on a temporary visa, having a clear path forward toward permanent residence or citizenship should be a priority. If you're a green card holder, seriously consider naturalization if you're eligible. The more secure your status, the more protected you are from changes in immigration policy and enforcement priorities. Part 8. Resources for help. If you need help with immigration matters, including concerns about how pending legislation might affect you, there are resources available. The USCIS website at uscis.gov is the official source for immigration forms, processing times, and policy guidance. You can check case status online, find processing times for different types of applications, and access a wealth of information about different immigration benefits. The USCIS Contact Center can be reached at 800-375-55283. They're available Monday through Friday from 8 a.m. to 8 p.m. Eastern Time. They can answer general questions about immigration processes, help you check case status, and direct you to appropriate resources. If you need to find an immigration attorney, the American Immigration Lawyers Association has a lawyer search tool at illier.com. This allows you to search for immigration attorneys by location, language, and specialty. All attorneys listed are ALA members who meet certain standards for experience, insurance, and continuing education. Many communities also have nonprofit organizations that provide free or low-cost immigration legal services, particularly for vulnerable populations. USCIS has a Find Help in Your Community page on its website that can help you locate these resources. Remember that you should be very careful about where you get immigration advice. Immigration law is complex and the stakes are high. You should work with licensed attorneys or accredited representatives recognized by the Board of Immigration Appeals. Be wary of notarios or people who aren't licensed to practice immigration law but claim they can help you. Unauthorized practice of immigration law is unfortunately common, and it can result in applications being denied, deportation, and financial loss. Let's wrap this up with the key points you need to remember. H.R. 875 is a proposed bill, not current law. It passed the House of Representatives in June 2025, but is currently pending in the Senate Judiciary Committee. Nothing has changed yet in terms of what's actually enforceable. If H.R. 875 becomes law, it would make any DUI conviction or admission a ground for inadmissibility and deportability, regardless of how the offense is classified and potentially applying to past convictions. This would be a significant change from current law, which generally requires aggravating factors for a DUI to create serious immigration consequences. Under current law, simple DUIs without aggravating factors typically don't result in automatic deportation or inadmissibility, though they can still create problems in certain contexts, especially for naturalization applications or if there are multiple convictions. If you're a non citizen, especially with any criminal history, including DUIs, you should consult with an immigration attorney about your specific situation. If you're eligible for citizenship, strongly consider moving forward with naturalization. If you're facing criminal charges, work with both a criminal defense attorney and an immigration attorney to protect your rights on both fronts. The most important thing is to stay informed through reliable sources. Don't make panic decisions based on misinformation and get proper legal advice for your specific situation. Thank you for watching US Visa Updates. I hope this video has given you clear, accurate information about HR 875 and what it means for the immigration community. My commitment to you is always to provide honest, factual information, even when that means correcting popular misconceptions or pushing back against fear-based content that's circulating online. Your future matters too much for guesswork or panic. You deserve accurate information so you can make informed decisions about your life and your family's future in the United States. If you found this video helpful, please consider subscribing to the channel and clicking the notification bell so you don't miss future updates on important immigration news. I also encourage you to share this video with anyone you know who might be confused or worried about HR 875 or other immigration issues. Accurate information is the best tool we have against fear and uncertainty. If you have questions about specific immigration issues or